Hi, we're going to talk today about winning before day one with Ben Townsend. I'm Rodney Peyton, and today I'm joined by Ben, who's a claimant personal injury lawyer known for meticulous preparation, deft management of experts, and a calm, constructive manner with the defense because he believes that relationships are one of the most important things and they can decide stuff that courts cannot. So across 20 crisp minutes, we're going to examine how to brief and trust experts, prepare for judges who sometimes have limited PI exposure, and how to use joint statements to clarify rather than confuse, and why a credible readiness to try a case can improve outcomes even when most of them never get near a court. So expect practical detail you can apply with your next file. So Ben, welcome to Beyond the Gavel.
Thank you.
It's great to have you here. We've had a long chat before this, and just give our audience a little bit of background as to how you got where you are today.
Well, I'm from Teesside in northeast England originally, which is a small industrial town for those that don't know. I started as a paralegal about 31 years ago at a small specialist PI and medical negligence firm on Teesside, and I moved to the bright lights of Leeds in 2004 to join my present firm, Stewarts, where I specialise in brain and spinal cord injury claims mostly, but also a smattering of high value, fatal amputation cases and serious burns as well.
Yeah, you sort of went straight there. You did law first and you stayed in law, is that right? A lot of people have gone all around the place. Did you had an idea right on that that's what you wanted to do?
Well, when I was at university, I was going to be a criminal lawyer, righting the wrongs in the criminal courts. But then I wanted to move into law and actually find a job to pay for law school. So I applied to every firm that I could find in Middlesbrough, asking for just anything. And the only firm that replied was this small personal injury medical negligence firm that I'd never even considered that field of law before, never occurred to me, but I just sort of fell into it as it happens. But I've never looked back. I've always found this area of law fascinating, and I've never regretted for a second moving into this area.
It's that intellectual curiosity, that gets you going. But it's interesting. I mean, med neg is different to personal injury in the way it
Mm.
is. No cases are on force, and there are a lot of nuances in it. So one of the things you told me is that it's a matter of your credibility with the other side and about relationships. Tell me about what you feel about the importance of relationships with the defense.
Well, I think there's so much of our job as injury lawyers is about managing relationships. You have relationships with your clients, with the other side, with the court, with experts, with counsel, and the relationship with the defense is very much one of the most important relationships in the case, and it needs to be managed in a similar way to the other relationships that you have. And to my mind, I think too few firms, certainly in the personal injury field, certainly the claimant personal injury field, place a proper premium upon the importance of that relationship and how vital it is to the success of the case. Not for the lawyers, for the clients on both sides.
And how do you cultivate that? And people coming up behind you, what do you tell them about how to do that, how to cultivate those relationships?
Well, the modern way of going about personal injury claims, for me, is not about overt aggression. It's about trying to be collaborative in our approach to the other side, being firm on the issues when firmness is required, but not being aggressive with the defendant's solicitor, the defendant's insurance company. Uh, the starting point should be trying to work together to achieve the best possible outcome for both sets of clients. Now, obviously, our duty is to the claimant, but we need to be able to understand the angle that the defendant's team is taking and why they do the things they do, and trying to build a relationship of trust between both sides, because that's the way you achieve the best outcomes, in my experience, generally for our clients.
And of course, it's not just once. You're liable to come across the same people again and again. And
Yeah,
if
I
you hit
mean,
them once, they're not going. They're going to remember it long term. So I think that that's a very, very good idea that you do that.
yeah.
Tell me, we're experts. I mean, as you've just alluded to, you're an advocate for your client. The defense is an advocate for their client. The expert is sitting in the middle. So what about your relationship with experts? Because there's always going to be that bit of tension.
Uh, you have to be careful in the way that you manage your relationship with the expert, because the experts in a catastrophic injury claim can be absolutely vital to the success of those cases. The key core expert, say in a spinal cord injury claim, is going to be your spinal expert, and the evidence that that expert is going to be providing in that case is going to be the basis on which the entire case is built. So you need to be careful in the way that you manage that relationship, in just the same way that you are careful with all the relationships in your case. And by building that relationship, by being careful in the way you manage your expert, you get the evidence out of them that you need to build your case properly.
Yeah. Tell me about that because, I mean, let's face it, some lawyers then try to say, can you not just say a bit more and come more over to my side of the fence? How do you square that about, I mean, obviously you're trying to get the best for your client. And the expert, if he starts to do that, then becomes a biased expert and can lose credibility. So how do you balance that?
I mean, the first thing to say, I suppose, is that because we're working in this field all the time, we know the experts that we can rely upon, who and the we know that they will take a particular view of claimants, and they will stand by it as well. And if they take a particular view upon a particular client, it isn't ultimately going to be useful for the claimant or their solicitor if that expert is willing to move around with their views about the claimant, because your entire case then is going to be built on sand, because you know that if you get to court, that expert is going to move around. It's going to have to concede that they have moved their evidence, and that is not a comfortable place to be. And that expert is not going to have the credibility that you need in court. So you really want an expert who takes a view upon the case, and if the evidence shifts, they will shift with that evidence, but they take a view about things, and that is where they will rest, and you can rely upon that.
So isn't it that reliability and credibility? So it
Mm.
does no help to anybody if you deliberately choose people you can manipulate, that you
Yeah,
need somebody who's in the middle that gives you right up front stuff you can rely on. Even if you don't like it all, it's stuff you can rely on. Said, okay, I accept that that's the fact and that's what the standard of care is. I take it than that. And barring new evidence, what this person says, they will stand over. And they will move with new evidence, as I expect another side to move with new evidence. But that their credibility is based on standing over what they say and that they have reasoning for what they say.
yeah, absolutely. It's just vital that the case is built upon expert evidence, that if you go to court, the expert's going to stand their ground under fierce cross-examination from, say, a top silk, who is putting them under real pressure. And as we know, it is a lonely place in the witness box, and you need to be able to rely on what your expert is going to say there.
Yeah, well, you do. And, people have come a cropper because, I mean, you've seen recent reports of experts going in there and refusing to change. For instance, a court takes a
Mm.
very that a poor view if a silk puts new evidence, even just say, well, I need to consider this, I need to think about this before I say anything. But said, no, it's the way it is. And that's, I think, one of the things we say is eminence isn't expertise or experience. They've got eminence. It sometimes attracts you to somebody, but that doesn't mean that they are good expert witnesses
Mm.
and that they have expertise in the courtroom. So,
Mhm.
expert is an expert, and a good expert is worth their weight in gold.
Yeah, because it's not just about really knowing their subject, it's being able to communicate that to people as well, and to deal with a judge, say, who may never have seen a personal injury claim before. They might be
Mm-hmm.
commercial judges, and never seen a personal injury claim. They certainly may never have seen injuries like your particular client has. So the expert has to be able to lead the judge in a way that they can readily understand through that medical evidence. So it's not just about understanding their subject, it's communicating it.
And then talking about that, I mean, we have the two sides. What's your attitude towards joint meetings, meetings of expert? Do you think you should set an agenda for that, or how do you set about joint meetings of experts with the defense? Do you talk to the defense, or what do you do to set about that meeting?
Uh, when I'm dealing with joint expert meetings, my personal attitude is that I'm dealing with experts that I know, that I trust, that I've used in many cases before generally, and I trust their expertise and their sense. And I am not in the habit of giving them a detailed agenda for dealing with the joint statement process. I am generally content for them to go through that process, which they have been through many, many times before. And they will, generally speaking, stick to their views, which have been honed over the many cases that they have been involved with. They may alter their views if the evidence changes, of course, but their views are their views, and I'm not going to dictate to them or give them a framework for expressing those views. They know how to do that.
Yeah, the worst thing of all is sit in court and somebody said, Doctor, would it surprise you to know? And you sit back and say, oops. Yeah, would it surprise you to know? Let me watch this video or something. You don't want any surprises like that coming out. That's the absolute truth. And you need someone who is not upset by it, somebody who is firm but not upset and not so full of their own ego that they don't like being questioned. I mean, one of the things that I say about an expert is that you should have that relationship where you can question them up front and say, please explain. I just don't quite get that. Just go through that with me and explain to me why you think what you think. Because it's
Yeah.
important that you get it, and it's important that your client gets it,
Yeah.
that you understand why people are saying what they're saying. And if an expert cannot explain in clear words to you why they feel how they feel, then maybe they're not quite as sure as you'd like them to be.
Yeah, and maybe they're not the expert to use. And hopefully, if you are in a position where you're using an expert, you can get a real feel for that by having an early conference with them with counsel so that counsel can put them through their paces and you get a feel for how they're going to present in court and how they, yes, they will stand firm on their views, but they will concede ground if, again, the evidence shifts around them. And if that expert is not going to be suitable to continue with, you've got to make a decision about whether you try and do something different.
Yeah, it's important. And it's also important, I think, from an expert to let you know what alternative points of view are. This actually
Mm.
comes down to informed consent when we're talking, to a patient. We're supposed to tell a patient, this is a course that I believe we should follow for the following reasons, but there are alternatives that you need to consider, like nothing or to do this. And it's the same in court, that an expert needs to be able to say there are alternatives or they're not. But if there are alternatives, what's the power of the alternative? What is the complication of the alternative? What is liable to come up? Because the silk wants to know that. Because no
Yeah.
way do you want to get into court and then the other side bring up something you haven't thought about.
Absolutely. And of course, we have to remember that the expert owes a duty to the court, not just to the party who's instructing them. So the expert, if there are alternative points of view, the expert should be volunteering that and should be saying, of course, some people in this field will say this about these particular circumstances. Now, personally, I don't take that view because for this reason. They
Yes.
should be alerting us to that and alerting the court to those alternative points of views, whether or not they agree with them. I think that's all part of their role, and it adds to their credibility when they have the ability, the confidence to talk about the pluses and minuses of alternative points of view.
And that's important for them too, because they're going to be asked. If
Yes.
it does end up in court, they're going to be asked, and therefore they need to have their answer.
Yeah,
There's no point in
absolutely.
being asked. You knew there was another point of view and being asked, and you can't argue, or discuss. I love it. Argument. The word comes across as if it's a fight, but an argument is just a statement of set of facts to counter something else without the emotion in it. The last thing you want in a courtroom is emotion. The silks sometimes try to get that, but the last thing you want is an emotion,
Yes.
with your expert. You want calm, consistent approach, and someone who knows what the alternatives are and can explain why they think. It doesn't have to be that the court accepts it. It
Yeah.
doesn't have to be that at all. It just has to be that you have a good reason for saying what you're saying.
Yeah, absolutely. The calm and authoritative is so important in the expert and needs to be part of what you're looking for when you are thinking about which expert you're going to be building your case around, because it is so important. Cases can
That's
be
why
won and
really,
lost there.
I really like the relationship between us as an expert and the lawyers, so that is there. There's a good relationship. It's a calm relationship. You can be asked questions. You don't get upset. You're available. That's always very important, isn't it?
Oh
It
gosh,
makes
yes.
everybody confident. And most of these cases, and especially actually probably bigger ones, apart from children, we have to kind of go and chat to the court anyway, but get settled by ADR. What do you think of the alternative dispute method? What's your experience with discussion around it? How do you get on with the ADR?
Yeah, well, uh, I mean, very few cases come to trial nowadays in the catastrophic injury field. The vast majority of cases come to some sort of settlement. Maybe, I don't know, 98% of cases will settle. So most cases are being settled via alternative dispute resolution. And there are a number of different ways to go at that, and they all need to be part of the uh, injury solicitor's armory. But it is vital from the point of view of the claimant that you are well aware of and practiced in making use of ADR, and that is only assisted by having a really good relationship with the other side, and that's one of the reasons why we at my firm is Stewarts, we work so hard on those relationships with defendant solicitors.
I can't agree more. That just to get that sort of mediation, it's not quite facilitated, but it's in that line where you are, really having a discussion. The alternative that other people say is, that's a cop out because, court says this is the way it is, right, wrong. Mediation says, no, there are nuances here, and this will balance what we give and all the rest. So you go into court, you get a decision, and it's all one way or all the other. ADR balances that up. And then there is then, I've heard other people say, well, I mean, that gives you a better chance, doesn't it? Because, even if it's weak, you'll get something. So how do you feel about that? That ADR helps weak cases.
Well, I think, I mean, as a rule, we don't take on cases that we aren't willing to back to trial. But just because we have that reputation that we will take cases to trial doesn't mean that every case goes to trial. And having the reputation that we are willing to take cases to trial probably helps us to negotiate. Now, with regard to mediation, I was myself originally skeptical about it before I tried it. I thought, well, I'm a litigation lawyer. I know how to negotiate. I'm perfectly capable of that. But actually, mediation genuinely does add something over and above negotiation. And in the right case, it can unlock a settlement in a way that a face-to-face negotiation cannot necessarily do. So a really skilled mediator can add enormously to the prospects of settling a case where there is, for whatever reason, a failure on one side or maybe both sides to properly understand each other's cases.
So do you like third-party facilitation?
Yeah, I think it can really help in some cases. Some cases, all you need is a face-to-face negotiation, but some cases genuinely benefit from having a mediator involved, in my experience.
And
And
I think one of the things, yeah, you brought up there about that was your willingness to go all the way. That means that you're confident in your case, in your evidence, and what you're saying. So that has to go right back to the beginning before a claimant becomes a plaintiff, doesn't it? It has to go right back to somebody coming in and you looking at their case. Now, there can be catastrophic injury, which is nobody's fault.
Mm.
You have to make a call right at the front end whether this is a goer or not, all the way. So, how do you manage, especially some of the injuries you're seeing are terrible injuries? I mean, how do you manage client expectation right at front?
Uh, Well, at the early stage, it means that you need to dig into the case as quickly as you can and find out as much information as you can straight away. And that's obviously a benefit for the claimant, that you're working hard on understanding their case from an early stage and you're able to give detailed advice at an early stage. And that's part of the detailed risk management processes that we have at Stewarts, that we take a very keen eye to the cases that we're taking on, and we don't wait for a year to 18 months to find out whether we've got a case or not. We work hard to get as early a handle on the case as we possibly can. But lots of cases carry an element of risk, and the important thing with claimants is being upfront with them so that from the outset they understand the risks that are inherent in their case. And it's by working hard to understand those risks yourself and being transparent with your client and having the sort of relationship where you can say to your client, look, this is a problem for us in this area and we can probably get over it, but it's not guaranteed.
So that's a matter of, how you handle it. And I think that that's very important. Some don't do that. They don't do it up front. And you've got to get the stuff early because memories change, in 5, 6, 7 years down the line. It's not the time to be saying, what exactly happened on that Tuesday? You
No.
want to get that out there. So you want an initial look at it, say, well, look, there's causation here and there's damage. And this was the standard that was expected. So you need that sort of screening or triage to begin with.
Mm.
and then managing the case, and then being able to take it forward. So that's very important from what I'm hearing you say, because when you do that, you believe in your case, and you believe that if it comes to it, we will take it to court.
Yes.
And
And
the other side need to know that.
yes, and the catastrophic injury world is not a large one. You're coming across, as we've already mentioned, the same people time and time again. And if you have a reputation that you won't take things to trial, that gets around the industry pretty quickly. And the defendants know that that's the way you handle things. And that is cutting your legs out from under you. And it's not
Your
doing your
brand is
claimants
very
any
important.
favors.
Yeah. It's two brands, the brand of Stewarts and Ben's brand. Both branding is what people say about you when you're not there.
Yes.
It's what they say about the company. So what's important here is not, I mean, there's Ben's brand. If Ben's doing it, okay. But if Fred's doing it, I'm not sure, because he's a bit wobbly. So the company, Stewarts, depends on your brand, that you're known to be this way. Somebody coming into the company depends on the company's brand, and the company's brand's formed from Ben's brand. So it's that circle that people coming in have got to understand, that they're being given credibility by the company and by those people who have gone before.
Yes.
They therefore have to behave properly, and
Yes,
behave
absolutely.
properly so that they build up their brand, and by doing that, build up not just the company's brand, but everybody else that works in the company.
Yes. And
And
that's
so
why,
in your group, it's so important that all of the people working in this field in Stewarts work together for the best standard.
yes, absolutely. And that's why supervision of cases and the way that fee earners are dealing with them is so important, because it is vital that uh, cases are being handled in the right way. And it's very much part of providing quality assurance to the clients that cases are properly supervised, so that it's not just the fee earner with day-to-day charge of a case who's looking at it, but also somebody else as well. And all of our cases are supervised, including mine.
Isn't that important? And isn't it important you say that? Isn't it important you, as a very senior person, says, I need to be transparent. I need to have my reasoning and logic examined. And
Hmm?
that's not critical, that's critique. That is, tell me why are you taking this on, or what have you done so far, where are you going. So lastly, can I ask you then, this tendency for young people coming in and say, can I work from home? What do you think about that?
I understand why people like working from home. Now, for me personally, I like to come into the office every day. I think it's important, as I lead the team here at Stewarts in Leeds. I, I, I think it's important that people can see you. And I think it's important that you're there providing guidance and support to other members of the team. I just don't think there's a substitute for that. So I am not massively keen on working from home myself, but maybe that's my generation.
Well, maybe there are times you want to do that, no distraction, that you want to really concentrate on your brief and get it sorted. But there's a reason for doing that.
Yeah,
It's not just, this is how it works and I would prefer to be there, because the relationship thing again, if somebody can't knock your door and say, hey, Ben, help me here, haven't
yeah,
done one of these before, it helps the new generation understand the work ethic, understand without being put down in any way, but can talk generally and get advice from those who are older than wiser. And sometimes vice versa. They may have heard something you'd never heard before. So I think that mix and that interaction is so vital, which
yeah,
is why I have loved today so much. When I am giving a lecture, or you're giving a lecture, you're talking about your experience and your background. When I get an opportunity to have someone as experienced as you from Stewart's on here, then that opens my eyes to things and opens the audience's eyes to things that they may not have thought about and isn't in their own experience. So I thoroughly appreciate you being with us today. You've given us some absolute nuggets, which I believe would be of value to every member of the legal profession listening in. So Ben, thank you so much. I appreciate it today.
Thanks ever so much. Really good to see you.